Good afternoon. Hi, good afternoon. We're going to get started here in exactly 8 seconds. It's just an odd number. I thought I'd throw it out there and see if anyone responded. My name is Amy Westrup. I'm the Executive Director of the ACC of Wisconsin. Thank you so much for coming out today for this presentation. We just have a little bit of housekeeping to take care of. I know that there's a CLE sign-in. Everyone got their name tags. And then I believe that there's a certificate in the folder from Husch Blackwell as well. We will be applying in Wisconsin and Illinois, I believe, and so I'm glad you're all here. Please make sure to sign the certificate and sign in appropriately so that you can get your credit. I know end of the year, people need to report. So like I said, I'm with the ACC of Wisconsin. I know there's some new faces here, so welcome. We appreciate that you're here. We know that everyone is very, very busy, and so we love when our members and even non-member guests can come and join us for these presentations. And we certainly want to thank Husch Blackwell. Husch Blackwell has been a longstanding partner with the ACC of Wisconsin, both locally and nationally. They never cease to impress me with just their creativity and their willingness to put on programs that sometimes seem a little goofy. And we actually called them about this one and said, hey, what do you think of this idea? And they just were like, yeah, this is great. And they ran with it. So we're always so appreciative of that because, in-house practitioners have they have a unique practice, and we are always trying to listen to our members and provide them with content and programming that they need. So I will quit talking, but I will say that we do have a new website and additional programming for important dates for next year, and any programming that we have for the remainder of the year is posted up right on the front page of that website. So please hop out and take a look. It has some save the dates for important dates for 2020 as well. If you ever have any questions about membership or anything having to do with CLE or your ACC membership, anything ACC, give me a call. I'm always available to talk to you via email or pick up the phone and give me a ring. Without further ado, I'm going to introduce Eric and Ann. They've put a great presentation together for us, and it's actually being recorded so that members throughout Wisconsin can enjoy the programming as well. So without further ado, Eric Eisenman and Ann Maher. Thank you.
Thank you. Thanks very much. Thanks for the introduction, and thank you for coming. As Amy said, my name is Eric Eisenman. I'm Vice Chair of Husch Blackwell's Labor and Employment Practice Group, resident here in the Milwaukee office. I would say that I'm qualified to talk about this today because I actually appear in one of the cases that we'll talk about today. I may have been especially zealous in asserting the privilege on behalf of my client, and we'll talk about whether that worked out or not. My partner Ann, who I'll let introduce herself, may have some more other less salacious experience that's relevant here.
I think I do. Hi, my name is Ann Maher. I'm a commercial litigator here in Husch Blackwell's Milwaukee office. I don't know that I'm eminently qualified to talk about this in particular, but I have spent more than 30 years handling commercial litigation of all types and trying to protect my in-house lawyers from having to appear as witnesses at depositions. I've also spoken and written recently about 30B6 depositions, which some of you may have been involved in before if you have any kind of a litigation practice, and identifying witnesses and trying not to have people like you sit as 30B6 witnesses. So I think we've put together a nice, hopefully, informative program for you, and I'm going to let Eric start. We're going to kind of tag team this a little bit. Please feel free to ask us questions, and we'll do our best to answer them.
Yeah, and one of the things Ann proposed, and I think is a good idea, is we were wanting to just get a sense, from folks in the room, how many of you have had to be witnesses in proceedings in your capacity as a lawyer? So maybe close to 50%. As we were putting this together, we were wondering really how common is it? And as we started looking at the cases, there's a lot of different contexts where this can come up. And it happens more frequently than some of us, I think, wish that it did. So this is where we're going to try to go today. We're not going to just be talking about the preparation for depositions of in-house counsel, although that's what the topic is, and we'll definitely hit on that. We'll also talk about some other concepts more generally, many of which you're going to be familiar with. But we'll talk about how the rules of civil procedure apply to these kinds of depositions. We'll talk a bit about some what we think are interesting court decisions that have interpreted the scope of the permissible questioning over the years. We'll talk about this, which you know more about than we do because you live it. How the difference between business advice and legal advice is going to impact what you can and should be talking about in the context of a deposition. We'll talk about practical ways that you can prepare someone in your office, or that if you're the one that's going to have to give a deposition, should think about preparing, as well as some of those ethical concerns which might be unique to in-house folks. And then finally, some best practices and tactics for responding to those notices or subpoenas when they come up. So again, to start with sort of how this applies, right? As an overarching framework, it's Federal Rule 26, which is going to govern the framework of the sort of questions that can be asked in this context, like all discovery. So Federal Rule 26 has got this language in it and has been routinely held that it should be liberally construed to permit broad discovery. But that highlighted language is language that was added in the 2015 amendments, right? Which was this language that was added to address proportionality. I'll click back actually, so we'll read this one as it reads in the rule. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, okay? So that proportionality language is what was added. And these were some of the elements that we've seen developed both in the commentary and in some of the cases about what that proportionality really means, okay? Specific factors like the importance of the issues, the amount in controversy, the party's relative access to relevant information, their resources, the importance of discovery in resolving the issues, and then whether the burden or expense of the proposed discovery outweighs its benefit. And I guess I'm interested in your thoughts, or anyone in the room, you whether we've seen courts actually applying this proportionality test. I have some anecdotal experience that, when you're making a motion to quash or you're raising an objection, this is something that I think we find ourselves relying on. But I wonder if you've seen courts sort of honoring the spirit of this.
Only on a few occasions in my experience so far, and it's usually been with respect to written discovery, not depositions, but some of the cases that I've read in the context of preparing for this presentation have indicated that the courts are looking at proportionality in terms of the burden, particularly in the 30b-6 context, on a company or a witness like an attorney in responding to particular discovery, including depositions.
Yep.
Others?
Yeah, I think that makes sense. And you'll see in some of these cases that have addressed what sort of questions and how far you can go when you're deposing an attorney that are hitting on some of these same topics. Can the other party get that information somewhere else, right? What other attempts have they made? Have they exhausted alternative avenues? I guess the interesting ones to me are the ones that strike me as a little sort of ambiguous. The importance of the issues. I mean, aren't the issues in the litigation important to the litigants regardless of how big they are? But I guess what the commentary is suggesting is that from a public policy perspective, and what's interesting is, one of the cases that established the rules in this framework, which Ann will talk about in a minute, is a big personal injury case about auto safety, right? So in that instance, you could see a plaintiff arguing this is a critical life or death scenario, and that should impact sort of how we're viewing whether we should be permitted to ask those questions of in-house counsel. So those are some of the elements. And then, just functionally, the two ways that an in-house counsel could be compelled or could find themselves in a deposition. The first would be under the standard request under Federal Civil Rule 30A, when a deposition may be taken, right? This is a typical notice of deposition that you might serve on the other party. The highlighted language there indicates, as you'll recall, that the attendance can be compelled by a subpoena under Rule 45. So, if the other party wanted to specifically take the deposition of an in-house lawyer, they could name that party and issue a subpoena for their deposition. And the alternative one, which Ann has alluded to, is Federal Rule 30b-6. Now, the nice thing about 30b-6 is under virtually all circumstances, the party receiving that deposition notice is going to be the one identifying who's testifying based on the list of the topics of questioning that are provided. But in some instances, a party may consider having an in-house attorney do that. And we'll talk a little bit later about the specific concerns that you have or considerations if you're gonna make that choice.
So I want to start in this context with the case that seems to be the seminal case in the context of deposing in-house lawyers, which is the Shelton versus American Motors Corporation case. And it is cited throughout, up until recently by Judge Sattmuller in a case in the Eastern District for determining whether it's appropriate or not to take the deposition, or necessary, right, and proportional, to take the deposition of an in-house lawyer. Let me tell you a little bit about the background or the facts that gave rise to the determination or the decision in the Shelton case, which is out of is the citation there? Somewhere.
8th Circuit, I think,
yeah,
right?
It's an 8th Circuit decision from 1986. I'm going to see if it's a district court decision. Yeah, no, it's an 8th Circuit decision from 1986, so, it's not new. It was a wrongful death case. The parents of a young woman who died as a result of a rollover accident involving a Jeep CJ5, I don't even know what that is, sued AMC alleging that strict liability, negligence, failure to warn, et cetera. The plaintiff filed a notice to take the deposition of Rita Burns, who was an attorney employed in the litigation department at AMC, who was assigned specifically to the case as AMC's supervising in-house lawyer. AMC sought a protective order and moved to quash the deposition. The magistrate judge granted the protective order with respect to certain topics in a separate 30b-6 notice, but denied the motion to quash Rita Burns' deposition. The plaintiffs deposed Ms. Burns, but she refused to answer a lot of questions on the basis that the information was either work product privilege or attorney-client privilege, not surprising. And the questions that she refused to answer primarily concern the existence or non-existence of documents, which I thought was an interesting fact, particularly in light of how the court ruled in the case. They moved for sanctions. Let me just read to you what questions she was asked. So she declined to disclose whether she knew of the existence or non-existence of documents in AMC's possession reflecting all manner of things, computations, diagrams, charts of the rollover tendency of the Jeep CJ vehicles. She acknowledged statistical tabulations about the rollover of Jeep CJ vehicles. She acknowledged that she was aware of the existence of documents reflecting tests made by independent agencies that were retained by AMC, and all kinds of things she acknowledged, but she refused to answer questions about the existence of some documents. And it goes on and on about things she refused to testify about. The magistrate judge orders her, the plaintiffs moved for sanction. The magistrate judge ordered Burns to give her deposition before him so that he could rule on objections. Interesting. She appears, she again refuses to respond to questions concerning her knowledge of the existence or non-existence of certain documents.
And that's what I think, that fact when I read that case really struck me, right? You have to be pretty damn confident about, your privilege basis to say, not only am I not going to answer the questions in the deposition, but I'm going to say to the judge who's ordered me to give it, and I can't remember if it was an in-camera deposition or not.
Yeah, I don't remember either.
But she said, no, I need to stand on this privilege objection because that's critically important. And I think that took some courage on her part.
I do too, and on her counsel's part. that worked out in their favor in 1986, frankly. I don't think, given the history, the cases that have been decided since then, I'm not sure it would now. Her answers to the questions were, any information I have concerning documents which might possibly be responsive to your question, I've acquired solely through my capacity as an attorney for AMC and my efforts to find information which would assist me in defending the company in litigation, and therefore I decline to answer those questions. So he overrules her objections, most of them, on the grounds that the information wasn't protected by either of the privileges, and ordered her to respond. She was instructed by counsel not to answer. The district court, there's an appeal to the district court judge, enters a show cause order why she shouldn't be held in contempt, and why sanctions, including default judgment, shouldn't be entered against AMC.
This was making me nervous as I was reading this case. I was like, well, I don't know what I would do.
Again, it was 1986, which is before I started practicing law. The district court granted the plaintiff's motion for default judgment.
They granted, so that was the remedy. The court granted the motion for default judgment because she refused to testify.
On the issue of liability, so there was going to be a damages case, saying that neither objection could properly bar inquiry into her mere knowledge of the existence of documents.
Because it wasn't what we would call privileged communications. It was her mental impressions, essentially, of the documents that she had reviewed.
Right. Well, and that's ultimately what the court held on appeal. So the court held the mere fact that the district court held the mere fact that the documents or knowledge of the documents came to her while acting for the client is not sufficient to invoke either of the privileges, which seems to make sense. But the question on appeal was whether a deponent's mere acknowledgement of the existence of corporate documents is protected by the work product or attorney-client privilege. And the Eighth Circuit held that where the deponent is opposing counsel, which is critical, and you'll see in some of the following cases, and has engaged in a selective process of compiling documents from among voluminous files in preparation for litigation, the mere acknowledgement of the existence of those documents would reveal counsel's mental impressions and are protected as work product. So there was a strong dissent holding that AMC was stonewalling and merely attempting to frustrate the trial discovery process and withhold documents in its possession that are not protected by the attorney-client work product privilege. Having said all of those things, Shelton seems to be the case that gets relied on by district courts and courts of appeal consistently, holding that these things. In order to take the deposition of an in-house counsel, the party seeking to take the deposition needs to show that no other means exist to obtain the information than to depose opposing counsel. The information is relevant and non-privileged, which makes sense, right? And in fact, I don't know why this information wouldn't have been relevant to the case, to the Shelton case, and it's crucial to the preparation of the case. And if all three prongs aren't met, a court can prohibit the deposition, and in this case, the court found they weren't met, and therefore reversed the default judgment, and they had to proceed. I don't know how this case turned out in terms of the subsequent proceedings, but had to proceed without the information that Ms. Burns had.
Question in the back.
And it was overruled because there were other means of obtaining the information?
Yeah, I think so. Yeah. I mean, the problem I had with that determination was that it seems to me that the facts in the case were they had taken 21 individual depositions. They had served a 30B6 notice with 10 topics for discovery. And they had done a lot of discovery, a lot of which AMC, there were lots of motions for protective order, motions to quash, motions to compel. I mean, it was a big mess. This was kind of the end. They finally noticed her deposition to try and get some of what they thought, I think, were underlying facts. So I don't think I answered your question. I'm going to look back at the case and make sure that that was the sole basis, Jim. So that's as a backdrop. There are subsequent cases, including the in re subpoena issued to Dennis Friedman, which have backed off the Shelton decision a little bit, right? Saying that the court should take a more flexible approach to the determination about whether an in-house lawyer should be deposed, that Shelton was too strict. And saying that the court has broad discretion, right, which is what Rule 26 says. So this Friedman decision is, and it's an adversary proceeding. Some of our bankruptcy lawyers in the room know what those are. I try to stay away from those, against directors and officers claiming, of a company, claiming breach of fiduciary duty with respect to a merger between two home improvement companies. So that's the underlying case. The directors, in defending the case, claim that they relied on an attorney witness's advice regarding their fiduciary obligations and the business judgment rule. And those fact witnesses, right, the defendants who were the directors, couldn't remember a lot of details about this defense, right? Or they had inconsistent testimony about the defense. And so, so the court the motion to compel was filed, or motion for a protective order was filed, and then Judge Sotomayor ruled that—
Then Judge, now Justice Sotomayor, which is one of the reasons this case will pop up and be cited now, right?
Right. She goes through the whole analysis of the facts of the case, and Shelton distinguishes Shelton and decides that this witness is not a litigator. Okay, so not opposing counsel. You're not trying to take the deposition of opposing counsel in the case, and was not counsel of record in the lawsuit. So you're not trying to play some kind of a game and get the mental impressions. There's not going to be a work product argument here. And it's just a different situation. Distinguishes Shelton and holds that the fact that the deponent is a lawyer doesn't automatically insulate the person, inside or outside counsel, doesn't automatically insulate that person from a deposition, and that we ought to approach this more flexibly than they did in Shelton. Does the deposition impose an inappropriate burden or hardship on the responding party? Well, in this case, the court didn't know enough to know whether it would impose an inappropriate burden, but said, they haven't shown me that burden. That means, I'm going to have to spend time preparing myself to have my deposition taken. That's not burden. Everybody has to do that. It's not an inappropriate burden. The party opposing the discovery carries the burden, showing that it exceeds the scope of Rule 26. It's not proportional, right? The information is not relevant. Clearly, this information is relevant because these defendants are claiming, I relied on this lawyer's advice.
And that's one of the things that I think this case sort of resets the equilibrium a little bit, because you have that Shelton decision from the 80s, which set a very high bar basically to be able to take the deposition of an in-house lawyer. This case says, remember, Rule 26, the presumption is that it's going to be discoverable in most instances unless it's privileged. So it requires the party who's opposing it, who would be filing the protective order, to show why it exceeds the scope.
Right. And, I think more importantly, they talk about the fact that you have to show up at the deposition, object on a question-by-question basis, because there may be some privileged information that's being sought at this deposition. There may be some irrelevant information, but the real key issue of whether the in-house lawyer, you all, or an outside lawyer needs to sit for the deposition at all really is dependent on what they're going to ask you. If they're going to ask you about facts, and we'll get to this, maybe I'm going to turn the page and I'll get to it, but if they're going to ask you about facts, unless somebody else knows those facts too, and you're not the only person who knows the facts, if they're going to ask you about facts, there isn't any reason why you shouldn't be deposed. They're not going to ask you for work product, privileged information, or attorney-client privileged information.
The other thing that you mentioned that I thought that In re Friedman case distinguished a bit was, and you emphasized that in that Shelton case, although it was an in-house lawyer, she was identified as in-house trial counsel. And the fact that she was directly involved in the preparation for and handling the litigation. And I think Justice Sotomayor said that it's going to be a different scenario when it's an in-house lawyer who may not have been directly involved in that trial or the litigation.
Right. So in the Seventh Circuit, where we all practice, or some of us practice, the U.S. Court of Appeals has not adopted or rejected Shelton, and However, many courts within the circuit are following the criteria, but I think they're really looking at a more flexible approach when I read these cases. So this PAPS licensing case, which is out of the Northern District of Illinois, talks about the rule of Shelton is limited to the depositions of counsel with roles in trial preparation, right? So back to Shelton being this in-house lawyer who was, deciding which documents were important, sorting through documents, and the court commented about protecting against abuses of opposing counsel was the goal of Shelton. We don't want people to say, oh, I'm just going to go straight to the lawyer. It'd be so much easier if I could just ask the lawyer because they know all this stuff. That's the goal of it. But when there is no other way to get the information, right? Or you should be looking at all of the factors, I guess is my point, that are set forth in Shelton and in the following cases. The United States Bank Association, same thing. So mixed results. So you really need to look at where you are, which circuit you're in terms of how they're going to approach the issue of in-house counsel, outside counsel being deposed. Yep. Oh, incidentally, the PAPS licensing case was a patent infringement case. And one of the things that I found interesting about these cases, as well as the 30B6 cases, is that they often come up in patent infringement cases.
In fact, there was a quote in that case, which
Yep.
I think the judge said something like, this
Yep.
actually happens more frequently.
Yeah, they are particularly frequent in patent
Yeah.
litigation. So for those of you who might practice in that area, be warned, right? That is an area where the courts have found those issues come up, and well, this Apple case is a patent-related case, and they're more likely to allow for a deposition.
That PAPS case was kind of funny. It was like there was a guy who was an in-house counsel for that for PAPS, and they sent, while he was the in-house lawyer, sent a bunch of demand letters and cease and desist letters to Apple while he was employed, and then he left that company, and then several years later, Apple tried to depose him as part of the case, and he basically said, "Well, I don't know anything about that," even though his was the name that was on all the letters.
Right. I haven't worked for them in a long time. Let me just one note. So the question then becomes, why is a different standard applied to in-house counsel, or is a different standard applied to in-house counsel? And the answer to that question is, they often perform non-legal business functions. In other words, you might be deposed if you are not providing legal advice to your client, right? And the court might sort through that issue. These cases don't involve that, the ones I've talked about so far. But if you aren't dividing those roles, you may end up sitting for a deposition because you might have given business advice or sat or been involved in a business decision where you were not providing legal advice. So if you're serving in dual capacities, and we'll talk about this a little more later, it can present a problem. You may be more likely to be subject to a deposition.
And that's a good segue. I mean, this is going to be review for you guys, but it's relevant to sort of set the table. The privilege exists and it applies because of the way that it's intended to apply. Confidential communications between a client and a lawyer made for the purpose of seeking, obtaining, or providing legal advice. And the intent is to foster candor in the attorney-client relationship. So, these elements are sometimes don't exist when we're talking about just simply rendering business advice. And that's why courts are saying we're going to draw a distinction. Now, what the courts have done is they've said, okay, it's inevitable that in-house counsel is not always going to be able to take off one hat and put on the other one, right? The advice that you give to your clients sometimes includes both business and legal advice. So the question becomes, how do we draw that line and determine, whether the privilege actually applies? And so, what the courts have said is that they're going to apply the primary purpose test. And I think one thing that I picked up as I was reading the case, the way to think about this is a primary purpose, not the primary purpose, okay? The law does not require, in at least the vast majority of the cases, that legal advice be the only purpose of a communication in order for it to be deemed privileged. But it must be a primary purpose. And I guess, that's an area where it would be helpful if we had sort of a black and white test. But, what does a primary purpose mean, right? But you've got here, we cite to the Federal Trade Commission case there, A court may find that these attorney-client communications have multiple purposes and may still be privileged, as long as legal advice was one of the significant purposes. So one of the places where this comes up a lot, and I've got, I think, a separate slide on it later, is this context of emails that have attachments on them, right? What if the email is very clearly attorney communication, privileged communication? Does that automatically imbue that attachment with that same privilege? It will not surprise you to find that the answer is no, okay? The email attachments are going to need to be analyzed independently of the original email, and that unless we can make that separate demonstration, they're going to fall outside the privilege. They don't become privileged simply because they're part of the communications. There are things that you can do in the email, in how you label it and what you say in it, and we'll talk about this at the end with some of our recommendations that can strengthen your hand there. This is sort of just I think a repeat of some of the things that Ann said and that I said. You know, it's okay if the communications have multiple purposes, but as long as that legal advice was one of the significant purposes, you're going to have a reasonable basis to argue that it should remain privileged. I talked about this concept of two hats. The Solis case, Milk Specialties, this is the one where unfortunately I got to experience this firsthand.
I don't know this story.
We had an interesting case where we were representing a client who had received several investigations from the Occupational Safety and Health Administration. They had come in and they had done an investigation and issued a number of citations. And so what they did is they, at the direction of their in-house counsel, this was before we got involved, he had a non-lawyer, right? He had a non-lawyer perform what you would essentially say is an audit to determine how much it would cost to bring these things up to compliance if we wanted to do what OSHA seemed to be asking. But he even took these steps. He said in his communications, you know, for legal purposes. I mean, it wasn't really sophisticated, but he put the stamp on the communication that he was giving to this non-lawyer health and safety person to do this. They were subsequently, OSHA investigated again and sought these documents that had been prepared by the non-lawyer, but at the in-house counsel's direction. And we raised the defense that these were very clearly, even if they weren't privileged, they were clearly attorney work product because they were done at the direction of the in-house lawyer. What Judge Stantmuller said in that case is even though you had an OSHA enforcement litigation here and an OSHA enforcement litigation here, because this was occurring in a time period between those litigation, it was not in anticipation of litigation, and ultimately we're required to turn over those documents. But what we're pulling out of that case for this slide here is that, you know, he also made a finding in that case that the in-house lawyer, when he was providing that direction or analyzing those documents, was doing more than simply providing legal advice. The argument was that he was participating in decision-making in business pieces.
Yeah, I want to just read from this Teltron case out of the Eastern District of Pennsylvania, which I think puts it well. When a corporation seeks to protect communications made by an attorney who serves the corporation in a legal and business capacity, the corporation must clearly demonstrate that the advice to be protected was given in a professional legal capacity. This showing is necessary to prevent corporations from shielding their business transactions, clearly what Judge Stantmuller was alluding to, somewhere in between the litigation, you're giving some business advice, from discovery simply by funneling their communications through a licensed attorney. So in this particular case, the court held that the affidavit that in support of their motion for a protective order or motion to quash the subpoena wasn't sufficient because they didn't provide enough information about how it was that they were relying on them for legal advice.
This isn't news to any of you in the room, but I wonder if this is a good thing that you should remind your boards and your CEOs that simply bringing you into the meeting or copying you on the chain does not automatically mean that this will be a privileged communication, right? I think that's worth emphasizing. And I thought this was an interesting note, right? Titles, dual titles for you guys as in-house counsel, as corporate secretary or vice president or board member, those are not legal titles, right? You may be general counsel and VP or general counsel and corporate secretary. But if you're including that and that's part of your email signature all the time, you know, is that going to be a challenge for you or a hurdle for you when you're making the argument that, no, actually in this particular communication, I was acting in my capacity as counsel, right?
Right, and tying this back to you being deposed, right, to the extent that you weren't acting in your capacity as a lawyer, what's the argument for not getting deposed, right? They're not going to be seeking privilege or work product communication. So, making sure that you're giving legal advice.
Yeah. So this next one, I think we talked, Anne, you can give some examples of, how do we draw that distinction? How do we make that argument, or what should we be thinking about when we're creating those records?
So what should we be considering? Well, are they, I think that you should be considering whether they are really asking for your advice as a lawyer, right? Would you have been involved in this communication if you weren't a lawyer, right? Mm-hmm. Are they coming to you saying, hey, I need some legal advice? Or are they just copying you because they want you to know something? Or, they think, oh, we're getting into a fight with this company. They're not asking you to review the contract and see whether there's a possibility of a breach having occurred. What are my obligations under this contract? Can I terminate this contract? They're just copying you because there's some back and forth with the client. I don't think that's enough, okay? So are they requesting legal advice? Do they reference legal advice? Do you reference legal advice, right? You've asked for my legal advice.
Yeah, and we see that popping up in the cases sometimes, and I was thinking about it. I mean, sometimes it seems sort of self-serving. Like the law isn't supposed to be like, well, if you remember to include these magic words,
right? Well, that's not going to work.
No, but I do think that in some of these decisions, they basically say the failure to do that, the courts will cite as a factor for why they're going to deem that it's not covered.
Right. Yeah, and so the other thing that I have run into is circumstances where you sit on the board of your organization, right? For some reason, or you sit in on board meetings and something's just discussed. That doesn't make whatever is discussed a privileged communication. And if you're sitting on a board and there are people outside the organization on your board, for example, and someone does ask your legal advice, be really careful, because you've got a third party at your board meeting, arguably. Are you giving legal advice to someone who's not part of the, in some jurisdictions, not part of the control group, you got to be really careful if you're asked to sit at a board meeting and take minutes, for example, right? You're the corporate secretary. I think those are situations where you might be in a position where you're not giving legal advice. You're not even there to give legal advice, right? You're there because you're the secretary of the organization. You're taking minutes. So make sure that you know what hat you're wearing.
Yeah, and I think there are situations that I think Anne's describing where if you see this happening, you can respond offline to the person who's sending the message and help them understand that doing what they're doing is not going to give us the privilege in this context. And so help them sort of address it that way. I think there are probably also times where if you think that there is an argument that what they're seeking is legal advice, but they're just not expressing it in the way that's going to give you a strong argument, that you could turn it around and you could phrase your response in a way such that we could sort of clarify that. So sometimes there is a way to quote unquote save it, I guess, but it's important to sort of be aware of these ideas.
Right. I could give a whole separate presentation on the board situation, because a lot is going to depend, I didn't mean to get off topic there, but a lot is going to depend on whether your board is all company members, right? Or you have some outside board members, or you have people who are attending the board meeting who are not board members. So it's a whole complicated issue, but be cognizant of it, is my point. Other factors to consider: did you have only limited involvement in the matter? Was the document addressed to a number of individuals, only one of whom is in-house counsel? Copying lawyer, you guys all know this, it doesn't create a privileged document. And people think that, right? If you aren't educating your business people that they can't just copy you and make a document privileged, then you should. I have kind of a top 10 list, which actually business people might look at. I didn't include it here, but it's nice to say you can't do this, don't do this, if you want to make sure that this is a privileged communication. So you can't shield your business transactions simply by funneling them through the attorney, which is what I read before. That sounds like it says the same thing. So a couple of examples, and I think Eric probably has better experience with this than I. The places where you might not be serving in a legal function, right? Conducting investigations, is that, if you're the in-house lawyer conducting an investigation, are you acting in a legal capacity or not? Are you providing legal advice to the company? It could be, it might not be.
And I think if you yourself are the one that is doing it, it typically will be. But the area where you get in trouble is, are you an in-house lawyer who is supervising an investigation and having HR people conduct the interviews, for instance? Or there's a case over here that made my heart shudder when I was reading it, and it was a company that was anticipating and defending some Fair Labor Standards Act class action wage and hour claims. And they hired an outside company to be the one essentially conducting a survey and an audit to determine whether employees were properly classified as exempt or non-exempt. And what that decision said is that, some of that was actually work that was directed by the lawyer, but there were also functions, what they called sort of almost quasi-legal functions, that were performed by this non-lawyer entity, and that because it wasn't a lawyer that was doing it, even though it was at her direction, they were deemed to be not privileged.
Yeah, so if you're gathering facts regarding issues that might later be the subject of litigation, unless it's in anticipation of litigation, say it's 5 years earlier, 6 years, maybe in the Jeep case, this woman's gathering information about other accidents. Maybe that's in anticipation of litigation, maybe it's not. In the commercial context, are you looking at, to your point, wage and hour issues? How many non-competes do we have, right? Are they enforceable non-competes or not? That's going to be a legal issue. How many we have? How many people are covered by this? You do an acquisition, for example. You've got some people covered by non-competes, some people not. You're just gathering information. You're not giving advice. You're just fact gathering. So a whole variety of issues where you might be serving in a non-legal.
That last bullet is interesting, and I saw it pop up a couple times in the case. Negotiating a transaction. Transactional lawyers say, that's what I do. That's me being a lawyer. But some of these cases are saying, no, that's a business function. If what you're simply doing is negotiating with another party over business terms, that sort of communication isn't necessarily legal advice, right? And so, again, I think there's probably a way, if I'm being careful and thinking about it, for me to frame the communication that I'm having in that context so that I can strengthen that argument.
Right. And Eric touched on this a little bit before. Attachments to emails are not necessarily privileged, right? So you send something to somebody asks for your legal advice, and you send them the attachment. Is that going to be a privileged document? And it depends, right? They have to independently earn that protection. The AM General Holdings case out of the Delaware Chancery Court, where a lot of corporate transactional cases get filed, right? There's a Northern District of Illinois case called Muro versus Target Corporation, same thing. They're increasingly being found not to be privileged, independent of the email that they're attached. They have to fall within the context of privilege on their own.
And if you're doing a privilege log, you would need to log both the email and the attachment. We see that popping up in some of the cases too.
And the last scary thing for me, and I'm not sure I really understood this case, maybe you did, but in this Ravenel versus Avis Budget Group case, the court held that where in-house counsel hired the auditor to disseminate and collect questionnaires for an audit, and then asked the auditor to review the responses to make an initial assessment regarding classification as exempt or non-exempt, the court found that asking the auditor to review and assess the questionnaires waived the privilege, even though disseminating and collecting the information was permissible.
Yep.
And, it just boggles my mind because it calls into question all kinds of circumstances in which you, as counsel, might hire someone outside the company to do an audit of something or another, right? This was probably not work product or in anticipation of litigation. It comes up in discovery. So, is the auditor a potential witness at a deposition who was hired at your control?
What I thought about in this case, and I wonder what you think, Ann, would this outcome have been different if instead of the in-house counsel hiring the auditor, if it would have been outside counsel?
Right.
And
Right.
I think the answer is yes, or at least you would have given yourself some more ammunition, right?
Well, and isn't that true with respect to investigations into harassment or other workplace safety issues? not to try and sell outside counsel services, because I know what you all are trying to
Convenient
do.
that Husch Blackwell is telling you to retain outside counsel.
I hate to do that in these presentations, but but the fact of the matter is, my experience is that when you hire outside counsel for a very, a complicated or highly risky investigation, whether it be a compliance investigation, right? Someone said you're fixing prices or whatever, or an employee-related sexual harassment claim, you have a greater chance of being able to get the privilege to hold up.
In our OSHA case that I talked about, once we became involved, we actually had that same sort of analysis done, but it was an expert that we retained and, felt very strongly. OSHA didn't even try to get those documents in that instance. Not saying that we were brilliant lawyers, but we learned from the mistake that had been made. So.
Yep. So, in order to protect legal advice, limit the roles of in-house attorney to ensure information remains privileged, outline the written job responsibilities for the role of in-house counsel, distinguish between your business role and your legal role, right? When I'm doing this, I'm acting as a business person, right? I'm giving you advice about strategic planning, for example, right? Any of you sit in on strategic planning meetings for the company? Of course you do, right? So you're not giving anybody legal advice. That's business advice or business consultation. Separate documents in the ordinary course, not protected from protected. Mark documents with confidential attorney-client privilege. And the one thing I would say about this slide is be careful about this, because I don't know that if you don't do it regularly, right, which is really, really hard, you risk, if you say, well, it's my practice to label everything that's privileged, makes it easier for the outside lawyers when we review documents, but it doesn't help with an argument that a particular document you didn't happen to mark as privileged is indeed privileged.
If you're going to do it,
because you didn't follow your rule.
Make sure you follow the rule, right?
So I'm not sure, I struggle with this piece of advice because I don't know how anybody can do it regularly, right? This happens to be a privileged communication. I am telling you, giving you legal advice. Having said that, I do like you to start my clients to start an email. You asked for my legal advice about this issue. Here's what I found.
And that's those last two bullets at the
words.
bottom. And I alluded to those before in sort of a flippant way, but honestly, if I was sitting in your shoes, I would think about, making this sort of a regular part of my response when I'm touching in areas where I think I might have an argument regarding the privileges. Invoking these concepts is going to be a benefit to you if you ever have to have a fight about it. The other thought, interesting on that side, I thought was this concept of job responsibilities. I suspect there are job descriptions for the in-house roles that you guys have, but I wonder if they draw a distinction between the business and legal. And I actually don't know the answer to this, but I could see a scenario where if you did that and you drafted the legal responsibilities in a way that were fairly comprehensive, if that would give you an additional argument about, in this situation, I was acting in this legal capacity. Something to think about.
Okay. So when you get the notice, the subpoena or the deposition notice, a couple of those cases involve former lawyers for a particular client who get a subpoena, right? As opposed to, for those of you who aren't litigators, a deposition notice, which means you're a representative of a party to the lawsuit.
Right. And these are practical and touch on a lot of the things that we've already hit, right? If you get the subpoena, right, the onus is going to be on you or your business to quash that notice or to quash the subpoena or to try to limit the scope. So you need to know what the law of your particular jurisdiction is, the way that you would move to quash or move for a protective order. You see the citation there to this Eastern District case. That seems very similar to the Shelton case that we talked about before. That last bullet, right? Consider proposing a substitute witness or negotiating for interrogatories. As we look through these cases, that's sometimes something that the party who's receiving the subpoena is going to be proposing as an alternative. Doesn't always work. But I think taking those steps is going to make you look better and strengthen your argument if you ever get in a fight before the court about that.
And I just want to make a footnote about that Dewey case, which is a recent decision by Judge Stattmiller. Clearly, he doesn't like the attorney-client privilege or the work product doctrine. But Judge Stattmiller does speak to the Shelton issue, orders the deposition of certain Foley and Lardner partners who submitted affidavits in the litigation, basically with respect to facts. And the judge says, you know what, you made yourself a fact witness in this case by offering these affidavits. Now, I think there was a really good reason for them to offer those affidavits, but the judge said, you have to sit for a deposition. Denied the motion for a protective order, motion to quash. And so two very senior partners at Foley and Lerner are going to have their depositions taken. So, some strategic decisions are being made. I think they were the only witnesses with facts, but in any event, be mindful.
Mm-hmm. If you're going to file one of these motions to quash, the court is going to scrutinize very closely the affidavit that you're going to want to include to support that motion. And these are some bullets. They look familiar because there's some of the Shelton-related factors, but these are the sort of things that you'd want to see in that affidavit to support your position that you shouldn't have to give the deposition or that it should be limited. Talk about the fact that it was related solely to your role as in-house counsel. Highlight the ways in which the party who's seeking the discovery maybe hasn't exhausted these other alternatives. One of the reasons in Shelton that initially, like you said, probably they found against the defendant in that instance was that, that plaintiff had done other depositions, had propounded other interrogatories, had taken a 30B6. And then again, identify other potential deponents that will have the same or similar information. You remember that concept of you can't get it from anybody else is one of the elements in Shelton, whether that's still going to be enforced rigidly. But pointing out that, listen, plaintiff can get this information somewhere else is going to help you if you're trying to defend against that subpoena. Question in the back.
Some of these situations are not either or. A negotiating a transaction, what I say to the other side is not privileged. Legal advice that I give to my client that the way the transaction is structured presents the following legal risks. That is privileged.
Mm-hmm.
So you have this mixture of information. Should you file a motion to quash or to limit in those situations, which are fairly frequent?
If you were, interested in your thoughts too, if you received a deposition notice or a subpoena in a case like that, at the very least, I think I would file a motion for a protective order seeking a determination that any questions regarding legal advice that you rendered to your client when you were wearing that hat are off limits. Query whether you're going to try to quash the entire subpoena, I guess.
Yeah, well, and I wonder about the relevance of anything you said during the negotiations, right? Because there's going to be a merger clause in your agreement. So,
there's a good argument.
There's a whole bunch of other reasons why that deposition notice is going to have flaws in my mind. Frankly, I have not often in my practice had anybody try to take the deposition of one of my in-house lawyers unless I put them up, which I've never done, as a 30B6 witness, right? Which I wouldn't do, I don't like to do, but sometimes they're the only person, which we're going to get to in a minute.
Mm-hmm.
I just haven't had it happen, Jim.
And it seems like as we read the cases that some of that might be dependent on the forum that you're in. It seems like there are some circuits and some districts where this has become a more common tactic. And so I guess we'll keep our fingers crossed that people in Wisconsin will be as friendly as we think they are. And they're right, yes, yeah. It's the Wild West. Some just tips for things to do, again, to prepare. The recommendation is that you retain separate outside counsel to represent you if you're going to be giving a deposition as an in-house counsel. It helps eliminate those potential conflicts of interest and helps you receive the advice that you would need on privilege and ethics issue. Do the thorough preparation that you would usually insist on if you had outside counsel defending someone else's deposition. Make sure you understand what your own obligations are and what the company's position is regarding those privileged communications. Understand the subject matter and the other limitations that might be in place. Again, this is why there's value in potentially filing that motion ahead of time so you can get some clarity about what should or shouldn't happen at that deposition. This clawback thing here, I thought that's a good point, right? If you're going to be forced to give a deposition in this context, I think it would be important to see whether if you've got a protective order in the case that you've got that clawback language in there. And that next bullet about giving you some time to review the transcript so that you have an opportunity to address that inadvertent disclosure and or that you get to review it. And if there's something that you shouldn't have said, that there's at least you'll have a fighter's chance at going back and trying to make sure the privilege still applies. That last bullet again, think about what the rules in your jurisdiction are about what happens with you talk with counsel during a break in the deposition and whether that is privilege or whether that's something that they could ask you about during the deposition. You're still going to be obligated under this ethical duty of confidentiality. So again, make sure that you understand what your client, the company, directs you to do in this context.
Suggestions on how to flesh that out, especially what your client is authorizing you to speak on?
Well, I think the good example in my mind was the Shelton case, right? I mean, the witness in that case was very well prepared about what, you know, her client was prepared to disclose and had authorized her to disclose, and she was willing to accept sanctions in that case. There's another bullet here in a slide that we may not be able to get to, but this concept of make sure that you understand what you're doing and that you're not making a selective waiver on the fly. So trying to do as much preparation and think about the different directions where they may try to go ahead of time.
Yeah, I think you'd rarely be deposed without counsel, right? So, you know, experienced litigation counsel. And I take it back, I have defended 2 lawyers' depositions, but they were both my partners, right, who happened to be involved in the negotiation of, I can't remember the other one, 2 of them. One of them was a negotiation of a contract. I was actually litigating the case, and someone noticed one of my partner's depositions because I think he had drafted the agreement. And so we spent time, Jen, you know, talking about, and what was your legal advice to the client, right? And what other issues? I think there might have been a negotiation issue in that case. What did you say to the opposing party, right? Facts that weren't privileged. And so we spent time together talking about how to make sure I could object to things. And John would say to me, I think if I would testify, I think if I answered that question, I would risk violating the attorney-client privilege, revealing privileged information, right? And that's true with any deposition witness.
With the few minutes we have left, do you want to skip to that 30B6? I thought that was interesting, Anne.
I just gave a whole presentation on 30B6 witnesses last week and selecting them. But for those of you who don't know, there is a procedure in discovery where a party, and Eric talked about it earlier, can designate the corporation to testify on certain topics, because a corporation is not an individual, except because the Supreme Court says it is not an individual. It isn't a person for purposes of giving testimony. The 30B6 witness is required to educate themselves as to all the facts known by the organization on particular topics, right? And so you have to prepare a witness, or somebody inside the organization has to prepare a witness to testify on whatever topics they come up with. They are listed in the notice. And the topics need to be reasonable. It's a whole separate issue, but they have to talk about sometimes facts they learned from conversations with counsel and from review of work product. So care needs to be taken to make sure that questions that would elicit your mental impressions, right, by you as a 30B6 witness, which I would advise against you being, but you might have to someday, or another witness who learned something from you, right? If it's your mental impressions or your advice, we have to know, the outside lawyers or whoever's defending the deposition has to know, what is legal advice and shouldn't be revealed, right?
Well, and you touched on the main point, which is that, right, and there it is, designating an in-house attorney as that witness creates a set of risks.
Right.
I think you should think long and hard before, you determine that that's the person that best serves that role.
Right. I mean, again, I'm happy to share my materials on 30B6 notices with anybody who wants them. I spoke at a state bar seminar on it last week. It's a complicated area, choosing or designating a 30B6 witness and then preparing them. I shared a stage with a couple of other people, each of whom, experienced litigators here in Milwaukee, who said they have never used an in-house lawyer as a 30B6 witness. They wouldn't choose to do it. But I found a lot of case law where lawyers have been designated as 30B6 witnesses because for a whole host of reasons. And then there really is an issue about protecting the privilege. And any small waiver might be a broader waiver, right? Be ruled to be a broader waiver, intentional or accidental. So back to the clawback issue on that note.
Yeah. So, if we haven't sent them out already, Amy, I'm sure there's a way for us to get everybody the slides. for that we've put together. So I know we've sort of blown through the end here, but I want to make sure that we get you out of here on time and that we have a time for some cocktails.
Yeah.
But Ann and I are happy to answer any questions you have today, or if you'd like to email us. Again, we don't pretend to be experts, but we've read the cases, so I think we're ready to help you work your way through this.
Good. Anybody? Questions?
Okay.
Thanks.
Thank you.